Contract. An agreement enforceable by law is a contract. Simply, we can say, an agreement which can be enforced in a court of law is known as contract. A contract must have the following two elements: agreement and enforceability. It is also known as law of obligation, private law, part or branch of business law, etc. It is developed by principles of laissez-faire economy. Contract is based on Latin principle pata sunt servanda, which literally means agreement must be kept. We may define contract by using different scholars' definitions. Salmond. A contract is an agreement creating and defining obligations between the two or more parties. Anson. A legally binding agreement made between two or more parties by which rights are acquired by one or more to acts done or forbearance on the part of the other or others. Black Law Dictionary. An agreement between two or more persons which creates an obligation to do or not to do a particular thing. American Restatement of Law of Contract Act. A contract is a promise or a set of promises for the breach of which the law gives a remedy or the performance of which the law in some way recognizes a duty. National Civil Code, 2017. A contract is an agreement enforceable by law is concluded between two or more parties to do or not to do something. Thus, all contracts are agreement, but all agreement are not a contract. A legally enforceable agreement is termed as contract. Law of contract forms the oldest branch of law regarding business transaction. Contract law is an important part of commercial law because every commercial transaction starts from an agreement between two or more parties. Act regarding company and corporation, banking and insurance, sell of goods, partnership, etc. are all founded upon the general principle of law of contract. Law of contract particularly relates to the agreement. In agreement, these are certain rules what to do and what not to do. Such agreements are legally binding for both parties. The law of contract is applicable not only to the business community but also to others. Every one of us enters into a number of contracts almost every day. Criteria of valid contract or essential elements of contract. At least two parties, A, offer, B, acceptor. There must be lawful offer and lawful acceptance to create a valid contract. Lawful object, objective should be lawful object. The object of the contract must not be illegal, immoral, opposed to public law. A contract of such objectives is not enforceable by law, they are void from the beginning. Certainty and possibility of performance, the agreement must be certain, agreement must not be vague or indefinite. Free consent, it is the part, give his/her consent voluntarily and freely. It is termed as a free consent, so there must be free consent to create valid contract. Such a contract is voidable. Section 14 of Contract Act 2056. Consent is said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation, mistake of law. Capacity to contract, the party to an agreement must be competent to contract, otherwise can't be enforceable by law. Generally, following person are not regarded as competent to contract. Minor, unsound mind, disqualified person. Minor is a person who has not crossed the age of majority. Unsound mind means a person whose mental status is not so good or mentally disabled person disqualified by law. Lawful consideration, something in return, an agreement is legally enforceable when each party to be give something and gain something. The something given and obtained is called consideration. There is a general rule: no consideration, no contract. So, for valid contract, consideration must be lawful. An unlawful consideration makes contract void. Contract Act 2056 Section 2, D. Consideration means the promise made to do or not to do any work in return of doing or not doing of any work mentioned in the proposal. Intention to create legal relation and legal formalities. A contract signed without fulfilling such formalities shall not be legally valid. The agreement must be fulfilled in written, registration, stamping, etc. as per the law. Termination of a contract. Termination of contract means end of contractual relationship between parties. Here, pleasure or pain can be found. In a contract, the party have to fulfill their contractual obligation. When such obligation comes to end, the contract is said to be terminated. Contract may be terminated by two way. Positive way, by performance of contract. Negative way, by breach of contract or fail to perform the contract. Likewise, a contract may be terminated by an operation of law, agreement, impossibility of performance. Contract may be terminated by following ways. By performance, I, actual performance, when the contracting parties fulfill their obligations in accordance with the agreed terms, conditions, and time, it is considered to be an actual performance of the contract. 2. Attempted performance. The parties to a contract shall provide to each other such facilities as may be needed to perform the contract from their respective side. If not, then the party in default of the performance shall not be held liable responsible. By agreement, a contract may be terminated by mutual agreement. Novation. Parties agree to replace an existing contract with a new contract. Alteration. Parties agree to alter some parts of the contract. Then, the obligation under the old contract terminates. Rescission, remission, waiver. Parties agree to a lesser sum of money, or a lesser fulfillment of liability. By the operation of law. A contract can be discharged by operation of law in various circumstances and release its parties from their obligations, such as impossibility of performance, insanity of parties, death of parties, merger and insolvency. The insolvency of the party affects their ability to perform their obligations under the contract. By impossibility of performance, if it become impossible to perform a contract as a result of fundamental change in the circumstance existed at the time of conclusion of the contract, the act according to the contract need not be performed. By breach of contract. Simply, breach means violation or refuse to do something. Breach of contract means not fulfillment of contractual obligation. In case of breach of contract, goes terminated. Remedies for breach of contract. Remedy is a process in which legal treatment is provided by the court to the injured party. In a contract, there are at least two parties. If one party of it reject the performance of contract, then a question of remedy arises. According to National Civil Code 2017, following remedy are available to the aggrieved party. To refuse further performance of the contract. Compensation for breach of the contract. In proportion to performed contract, quantum meruit. Specific performance of the contract. To sue for an injunction. Power of court to make an order. Compensation to be ascertained in monetary value. Thank you for watching my video.